order. I'm, as you know, Eric Parker, the new co-chair of the committee, and Judge Alexander is here as well. And so I guess probably the first thing we should do, Rhonda, is get a motion to approve the minutes from our last meeting.
So moved.
Second.
All right, Judge Handy with the motion, Judge Oliver seconded it. All in favor?
Aye.
Aye.
Is anyone
There was
opposed?
a misspelling of Judge Shea's name, which I'll correct and repost it to the website. Phil Fish found that, so.
Very good. So then with that one change, it carries. We have two new members, right, Rhonda?
Yes, we have Judge James Abrams, who is the Chief Administrative Judge of Civil Matters. And we also have John Shugarts of the Waterbury Republican American, a longtime courts and police reporter there. Yes, he's on. Hi, John.
How you guys doing?
Good.
Good.
Very good. Welcome.
Welcome. Thank you.
Do you want to go around like we did the last time and have everybody introduce themselves so people know? I leave that to you guys, whether you want to do that since it's been a while.
It's your decision, Eric.
Oh, geez, you're pushing everything on me. Well, we just have the two new members and we introduce them, and going around the room on Zoom is kind of a nightmare. So let's,
Okay.
we'll hold off. If we have to do it in our next meeting, we will. But
Okay.
Going around a virtual room is tough. So
Okay.
I think, so welcome to Judge Abrams and to John. And I think we should maybe move on to the camera rules, the practice book rules. Melissa, were you going to talk about those?
Yes, I'm happy to talk about those.
Well, go right ahead.
So I wanted to start by thanking members of the media for your cooperation during COVID-19. As you may know, in the beginning of the pandemic, when we were significantly limiting the number of proceedings and the number of people in the courthouses, we reached out to Karen Florin, who was then the co-chair of the Judicial-Media Committee, to brainstorm ways that we could provide public access to proceedings and to documents while maintaining health. And what we came up with is the media was able to request audio recordings of proceedings. If a member of the media wanted to go into a criminal proceeding, they could do that, but we were pooling both video and still photographers. They could still request to be a pool. And we also provided an option for members of the media to request documents through external affairs. So we are still assisting with documents, but obviously the other requests are no longer needed since we have been opening up court proceedings more and more. But I really want to thank everyone for their cooperation. I mean, there was a whole bunch of new things coming our way, and everyone was really interested in working together to provide that required access and necessary access. So the changes to the practice book rules really have nothing to do with COVID. As many of you might recall, these rules are about 10 years old. And the rules for arraignments are different because clearly the arraignments happen on such a quick basis that there's no requirement for the media to provide 3 days notice for an arraignment. And what that meant was that we needed to set up some type of mechanism for the media to get requests in to a centralized location quickly. And the rules allow the chief court administrator to designate an entity to accept the camera rules for arraignments. Judge Carroll has designated the External Affairs Division, and Joe Pellegano in this office generally takes those requests. The practice book rules for any other proceeding in civil and criminal requires a 3-day notice and requires the media representative to email the administrative judge of the district where the proceeding is going to take place directly. And what has happened recently is that members of the media sometimes get a little confused and send external affairs the request that should go to the AJ. And on the other hand, to be honest with you, the AJ is getting these requests. They get all of the camera requests, and the arraignments, they really are just put on notice. They don't necessarily have to do anything. So there have been requests that have kind of been in limbo because there wasn't one person kind of shepherding them through to be sure that everybody knew what was happening. So the proposed rules changes basically will have the chief court administrator designating one entity, which will be External Affairs, to accept the media request for all proceedings, civil and criminal. And it will be the same situation where Joe will email the AJ, so they're going to know, but there's just kind of someone keeping an eye on the rules. And as we were going through the rules, we thought, well, if we're going to make these changes, let's clean them up a little bit. So for section 1-11A, we just added that the Chief Court Administrator designates someone to receive the email request, and that's in the arraignment section. The other thing we did is, if you look through the camera rules, there were different provisions that dealt with pooling, and you could see that some of the provisions were pretty heavy-handed, and I think it shows what has happened in 10 years. So we decided to make sense to make those provisions all the same. So if you look, we added in subsection H of section 1-11A that the judicial authority shall not mediate any disputes among media regarding pooling requirements. And then this language here in H is copied throughout all of the practice book provisions. So you'll see for section 1-11B, you'll see the language that I think is, not necessary, because the media can handle pooling requirements without any issue. This language says the judicial authority in its discretion may require pooling arrangements by the media. Pool representatives should ordinarily be used for video, still cameras, and radio, with each pool representative to be decided by the relevant media group. Participating media members of the broadcasting, televising, recording, and photographic media shall make their respective pooling arrangements, including the establishment of necessary procedures and selection of pool representatives, without calling upon the judicial authority to mediate any disputes as to the appropriate media representative or equipment for a particular trial. If any such medium shall not agree on equipment, procedures, and personnel, the judicial authority shall not permit that medium to have coverage at the trial. I mean, we don't need that. I just think it shows how far we've come in 10 years. So that our suggestion is to eliminate that, and again, use the same language we used in the arraignments. Then the subsection N is what we talked about, where we'll have the Chief Court Administrator designate an entity to receive all of the requests, including those for proceedings in civil and criminal besides arraignments. So that's subsection N. When we go to section 111C, which has to do with media coverage of criminal matters, again, we're using the same language that the Chief Court Administrator will designate an entity to receive the requests. And we eliminate in O that kind of onerous language about what the media has to do for pooling, and we include the same language that we've included in the other subsections. So, I mean, we view this as more administrative cleanup, but if any of you have any substantive suggestions that you think should be incorporated, I think now would be the time, because it has not yet gone to the Rules Committee.
Does anyone have questions for Melissa or comments?
Your Honor, if I could make a comment. I don't have any specific comments in response to these words, but it's more question about virtual hearings. And I joined a few minutes late, so if I missed any commentary on that, Melissa, I apologize. But I'm wondering if that's something that should be taking into account, because they seem like they're perhaps different, certainly in terms of timing.
I leave that to members of the media. I'd be curious to see what you have to say, because we followed the best we could the current practice book rules with regard to the pandemic. And of course, there were different accommodations that were made. So for example, if a member of the media wanted to photograph or videotape an arraignment that was done by remote means, generally speaking, obviously everything required the judge's permission, that member of the media received the Microsoft Teams link and then would follow the practice book and provide pooling to any other media that requested it. I mean, from my perspective, that worked very well, but I would be very curious to hear from the perspective of the media if that worked, or if you have a better idea for how to handle the remote proceedings.
If I may speak, I've covered a couple arraignments that have happened, and everything was via the Teams meetings, but I was physically present in the courtroom, and it was literally just me and the judge and the the essential staff, and there was a big monitor set up, and we took still photos of the monitor. So you had multiple people's faces. So then we later had to go and crop out. So we're getting just the defendant's face from the screen. So in terms of action quality, so to speak, it's a picture of people can tell it's a picture of a screen, but they understand that that's the way the court proceedings are being held during that time. And we haven't had any issues regarding that. I haven't actually had one where I got the Zoom meeting and took maybe screenshots of that. It's just been a couple where I show up where everything else is virtual, and we haven't had any issues.
That's good to know. Thanks, Laura. So do any of you think that we should amend the rules to accommodate the remote hearings, or do you think the way it's progressing right now is working fine and we should just consider the kind of administrative changes?
Melissa, is what Lauren saw as far as she was in the courtroom while other things happened via Teams the more common outcome, or would you say more people got the invite and all participated virtually?
I really think it depends. I think on the civil side, it's probably more likely that more people are going to be participating remotely. But I asked Judge Abrams if we were asked this question, if I could punt to him. So Judge Abrams, can I punt to you?
Sure, of course. You can always punt to me. Listen. Yeah, we're seeing our stuff is the minute that the court monitor hits the button and we're recording, we're also broadcasting on YouTube. The courts, I mean, technically, if someone wants to come in and watch an oral argument on short calendar and they're wearing a mask, they're more than welcome. But everything's on YouTube. I have no idea. I won't say there was universal enthusiasm among the judges when that was instituted, but everybody's living with it, and it seems to be working really well. I mean, I'd argue there's far more access to civil proceedings now than there was pre-COVID. And I think we're going to continue. I don't rule the world, but if I did, with the exception of jury trials and other things where physical presence is required, I think we don't have people driving to the courthouses. They're not paying to park. A lawyer can be in Stamford and New London in the same morning. It just seems to make a lot of sense to continue to do a lot of this stuff remotely. So,
And I would say for criminal, and I know I've been out of it, what Lauren experienced was pretty common, because I know in Bridgeport and Waterbury and Hartford that the judges certainly, it's an open courtroom. They are in the courtroom, the screen's there. And I know the media was always permitted to be present, again, wearing their mask.
Yeah.
Are the YouTube videos, this shows my ignorance, are they available after the fact for people, just like anything else on YouTube?
no, they're live.
They're live, only
Just live. It's as if you came into the courtroom. It's the same
Got
thing.
it. And this may just be me, Melissa, and this is all working fine, but it just somehow seemed that if I wanted to take a picture of something like that or deal with the YouTube thing, the 3 days was a little cumbersome for video, but maybe I'm wrong. Maybe it's still necessary in terms of giving the judges an opportunity to deal with any particular issues that crop up.
Bill, honestly, we haven't heard any complaints about it. As I said, we're open to it if members of the media have suggestions. But as you know, the vast majority of requests we get are arraignments.
Right.
And there's no 3-day rule for arraignments.
Yeah, I have not personally covered one of these, but I haven't heard a single complaint in our newsroom about the way it's been handled. So,
okay. As I said, my questions were perhaps a little informed by my ignorance. So,
well, I only asked my follow-up, Bill, to yours in the sense that if it seems like it's just being handled, and Melissa, correct me if I'm wrong, it's being handled just like the old requests where it's just that, now if it's a civil proceeding, before Judge Abrams, everybody's on Teams. If it's for the most part, everybody is, the judge may be in the courtroom, and so may be a reporter shooting a picture of a monitor. So I just don't know if it gets us anywhere besides adding language to deal with the virtual stuff. If the intent kind of is whatever the proceeding looks like now, we're going to treat it with the camera rules.
Yeah, that's what our thought was, Eric.
Lisa, do you have a question?
I do. Did I do this correctly? So as of right now, and I haven't done, unfortunately, too much courtroom work in the past year and a half, but as of right now, you can see civil either through Teams or YouTube, but criminal, you have to go to the courtroom. Is that accurate? For a reporter, I should say.
To the best of my knowledge, that's how it works.
Okay. And is there a particular reason why criminal wasn't included in that in terms of, Teams or for instance, what you're saying is, okay, if the reporter's there and everybody else is on the screen, everybody else is through Teams. So why couldn't the reporters cover it through that as well? With the understanding they wouldn't speak or,
Rhonda, do you want to take this one? I can add to it.
Yeah, and I think if it's a pretrial, we have provided on request, and if it's an on the record proceeding and a member of the media asks for a link, we do send it. We run it by the judge, but that has occurred. But there's nuances to cases. We had a case in Rockville last week with a defendant by the name of Peter Manfredonia. My understanding, he was the only person who was remote. So it was a remote hearing because he's incarcerated. But my understanding is that everybody else was in the courtroom. So while it was dubbed a remote hearing, there was no link to provide. So everybody came to court for that. It happens a lot with pretrials because those are most frequently the items that are marked as remote proceedings. The one thing we caution the media about when we get these requests is we can only guarantee that something is in chambers, quote unquote, pre-trial and off the record at that moment. We have no guarantee that someone's not going to choose to plead guilty and then it goes on the record in a courtroom before a judge in their actual presence. We have started telling reporters that there is that risk because we don't want to be held responsible if something happens and that they said, well, you told me it was off the record, and then a major development occurred with the case. So we have provided, the clerk's offices have provided it. Like I said, it's been primarily for on the record pretrials. I think the big criminal items, and Judge Gold would probably be best to ask about this next time, or Ralph. I think for the big criminal sentencings, pleas, I think the goal is to have it occur in the court, but I could be misspeaking there. Maybe Ralph or could add that.
Yeah, Rhonda, that's accurate. That's generally the intention of the judges in the criminal courts is that most hearings are going to be held remotely, but sentences, those are generally brought into court.
All right. I was just wondering if you're revising the policy in the practice, in the practice book, if this type of stuff, the virtual stuff, shouldn't be considered at some point. Obviously, it was kind of initially an emergency situation and everybody had to kind of feel their way through, but this could be the future, so I don't know if you want to consider that, but thank you everyone for responding to that.
Are there any other questions? Or I'm sorry, Melissa.
I was just going to say, I appreciate what you're thinking is, Lisa, but at this point, to be honest with you, everything is done really on a case-by-case basis. I really wouldn't even know where to start to put something down on paper. So if I may, what I would request is that if the committee is satisfied with the proposed rules changes, if you would approve them with the understanding that if we need to, discuss this further when we have more experience with remote. I mean, I think Rhonda and I are certainly open to making changes if we need to for remote. But again, at this point, I just don't even know what those changes would be.
So are we looking for a motion, Melissa, then? We're looking for a motion to approve?
Yes, please.
Someone have that motion?
So moved.
Second.
Who moved and who seconded?
Judge Handy moved.
Powell seconded.
Okay, thank you.
All right, we have a motion and a second. All in favor?
Aye.
Aye.
Anyone
Aye.
opposed? Hearing no opposition, the motion carries.
I think our next item is Judge Abrams, who's going to give us an update on housing court and the evictions, etc.
Okay. Throughout the last year and a half, it's been dynamic in all areas of civil practice, but far and away the most dynamic area has been summary process or evictions, mainly because of governmental action, both on the federal level and the state level. So what I was planning on doing, or what I was asked to do, was to briefly outline first what the feds have done, then what the governor has done through a series of emergency orders, and then I'm going to talk a little about what's going on today in the housing court and what I see in the future. First, I'll cover the federal action. Back in March of 2020, March 27th to be precise, the feds Congress passed what was called the CARES Act, which was an eviction moratorium. There have been two approaches. The federal approach has concentrated on the end of the eviction process, the execution process, when the tenant is removed from the property. The state focus has been on the filing, at the beginning of the action, has been on the filing of placing limitations on the filing of eviction actions, but we'll get to more of that. So the CARES Act barred was a moratorium on execution on parties where there were federally backed mortgages, and that's a substantial portion of our business, our federally backed mortgages, and it barred the executions on evictions. It also allocated funds for rent relief. Then, out of the blue, a little over a year ago, the Trump administration, CDC, issued a moratorium on executions that was effective September 4th. None of us saw that coming. That came out of the blue. It remained in effect until July 31st of 2020. So you couldn't, while you could file an eviction and get a judgment, you couldn't execute on the judgment. So the tenant remained in the property. It expired the end of July. However, there was as you may recall, there was a lot of reaction to it having expired. The CDC reinstated it several days later on August 3rd, and then the U.S. Supreme Court found that the CDC did not have the power to affect evictions, and that was so the moratorium was overturned on August 26th. Now, at that point, what we were doing was holding a hearing on every execution during the effective dates of the CDC moratorium. Every request for execution went before a judge, and the judge would determine whether or not that particular case, whether the CDC moratorium applied. At the time that the Supreme Court overturned the moratorium, we had over 100 hearings scheduled statewide. We decided to continue to hold those hearings. that someone, a tenant in one of those cases, could argue based on the fact that the hearing was held, that they had a vested right to a judicial determination whether the moratorium would apply. We're working our way. There are a handful statewide that are still being heard, but we're almost done. Basically, federal actions are no longer affecting, with the exception of that handful of hearings, federal actions are no longer affecting evictions in Connecticut. Now we go to the state. And again, the focus of the state action was not on the execution process at the end. It was on the filing at the beginning. So it affected whether you could indeed, as a landlord, file an eviction action. I'm just going to run through very briefly each EO and what it did. The first EO that affected evictions was 7G. It was effective March 19th of 2020. So when you think about it, everything sort of went off the rails, to the best of my recollection, the second week in March. So we're talking the CDC, the CARES Act was March 27th. The first EO was March 19th. So it was, for government, relatively swift action in the area. 7G suspended all non-critical court operations and timeframes. Everything was frozen. Then 7X, which was effective April 10th of 20, it was the first specific eviction moratorium, and it impacted, you could not file a notice to quit, which is the precursor to filing an eviction action, until July 1st, 2020, except of cases of serious nuisance. If somebody's operating a meth lab or something like that, then you could get them out, but otherwise, no. Then that was 7X. 7DDD, effective 6/29/20, extended the moratorium again to August 22nd, 2020. It also carved out rent due prior to cases where rent was due prior to February 29th of 20. So the cases that predated COVID, you could file actions in those cases. Next, EO 7000, effective August 21st, 20. It extended the moratorium to October 1st of 2020. Again, there was a carve out, the nuisance carve out, the rent carve out. And also what was added was if the landlord made a case that they were the ones who were going to live in the unit, then those evictions were allowed. Next was 9E, September 30th of 2020, extended the eviction moratorium to January 1st. Carve-outs remain in effect. EO 9H, effective 10/20/20, some technical revisions. I shouldn't have even mentioned it, it was all technical revisions. 9T, kept it, extended it to February 9th of 2021. 10A, extended the moratorium for the duration of the public health emergency. So there wasn't a date. Carve-outs remained in place. EO 11, effective 4/19/21, extended the carve-out until May 20th. Extended the moratorium to May 20th. 12B extended the moratorium to June 30th. Then, effective June 30th, we have EO 12D, which we're still operating under as of today. 12D, according to 12D, the landlords have to complete and submit their portion of the Unite Connecticut application. That's the funding arm for the federal funds before they file a notice to quit. So they have to say, hey, I've applied for funds. The landlords have to give tenants at least 30 days to quit, normally 15. Landlords have to accept rent up to the quit date as reinstatement. All residential notices to quit have to include a copy of the United CT flyer in English and in Spanish. And if the landlord or tenant apply for Unite Connecticut funding during the course of an action, a summary process action, further proceedings are stayed for 30 days. or until a decision on that application is made. Reports are that it took a while, but that the system is actually working. I know there was a landlord representative quoted in the paper maybe 2 weeks ago saying things were going well. I haven't received a 4-minute voicemail from Rafi Podolsky in about 3 weeks. So I assume that things are going well on the tenant's end also. As most of you were aware, I'm sorry, EO13 extended everything until this Thursday. I'm sure as most of you are aware, the House is in session now, Senate in session tomorrow, where they're going to vote to, the 30th is when the governor's emergency powers run out. So all the United CT thing goes away if his emergency powers are not extended. We assume if his powers are extended to February 15th, that he will extend the Unite CT orders throughout that period. We're certainly hoping so. So we'll learn tomorrow whether my sources in the legislature indicate that there is a chance that the emergency powers will be extended. So we're just waiting to hear, but we expect that the Unite CT, that the structure that was contained, I think it was in 12, whatever it was, those of you keeping score at home know, that's going to remain in effect, that the landlords are going to have to seek the federal funding before they file. And nobody appears to be screaming. What's happening now? In housing court right now, everything is being done remotely with the exception of criminal matters. We've just brought them back in live to sort of be in concert with what else is going on in criminal, where those are live. Everything else is being done remotely. Well over 90% of the landlords are participating via Teams. About half of the tenants are participating via Teams. The rest of the tenants are participating by phone. The hearings are happening. Business is moving. It's in many ways more convenient for the litigants in that they don't have to take a day off from work to go to court. The mediations are going forward remotely. The one problem we have is that it is in a well-run housing court pre-COVID, you had the mediation, and if the mediation failed, it was immediately followed by the trial, same day, which helped get people to yes. There were some courts where they got too bogged down, that wasn't able to happen. Now it's logistically, I think I'm okay saying impossible for us to link the mediation process with the trial process. So we've got right now a several-week delay between the mediation and the trial. That's not optimal. And as I mentioned earlier in the meeting, I'm very much on the lunatic fringe of keeping as much of our work remote as we can. But because of that gap, and I don't see a digital solution to that gap, that we will probably, when it's safe, one of the first things that will come back online is the summary process docket live, so that we can have the mediations and the trials the same day, because more cases will settle. I guess that's it. I'm open to questions.
So James, I'm just
Go ahead.
wondering about media coverage, because I know, back in the pre-COVID days, if you got a call from someone saying, hey, my landlord's throwing everybody out of our apartment building, it was super hard to cover, any of that stuff at housing court, not in any sort of knock on the judicial branch, but, they're in mediation, then they're here and the docket is moving. I'm just wondering, there's a lot of focus now on these rules and on these changing executive orders. Have you had experience with reporters trying to cover the housing docket now, and how is it going?
New Haven Independent is covering, I'd say on an average, we get a request on an average of once every 2 weeks, somewhere in there. They're intimately involved, run a lot of stories on it. I don't think we're getting that many other outlets that are interested. But it is apparently, I'm not hearing from them, so apparently.
Do you think it's gotten easier though with the remote, because it's, you know, the James Abrams hearing is on this Zoom link or whatever, right? So, you know, you can sort of track your case a little easier than trying to follow it around a courthouse?
Yeah, well, yeah, we both know the housing docket can be a little chaotic live. So, yeah, it probably is. I mean, I would think. You can't keep track, at least though, when it was live, you knew the mediation was going on. You weren't in it, but now you have no idea if it's taken place. Well, I suppose if you look at the court record, you can, but you don't know. It's just not all there in front of you on the same day.
Thank you.
Sure.
Any other questions?
Thanks. Thanks for listening.
Thanks for your presentation. It was excellent.
Oh, thank you, John.
Thank you.
Our next agenda item is continued discussion on the pandemic and covering courts. I think we've maybe talked about this in some of our other items. Does anyone have any other issues, reporters or judges or anyone that they'd like to raise?
Yeah, this is John Shugarts. I'd say that the only thing I bring up is that kind of consistency would be good across courtrooms. I found that in some cases, marshals don't quite understand, should the reporter be there, should they not? That was as of a couple months ago. So in other words, you know, I go in to cover something and there has to be this, you know, long chain of command that's got to go up and come back down before I can even go in the courtroom. And, you know, so that's kind of an issue, but other than that, I think it's been okay. All I'd say is that maybe if word could be passed down, you know, consistently, that'd be great.
Any other comments, questions?
Well, this is Chris Powell. If we're doing so well on time here, I'd note that, you know, there's a lot of complaints around the state from the Republicans and the legislature about juvenile justice. I find them a little funny insofar as, you know, we can't know what's going on in juvenile court because it's all secret. Would anybody from the Judicial Department care to express an opinion on whether we should, you know, open the juvenile court to the public? I've of course always wondered how we get away with secret juvenile courts when the state constitution says all courts shall be open, and those courts are by statute closed. I don't know if anybody in the department wants to, you know, get in trouble commenting on this issue, but it's I do have to laugh at the debate in the legislature. They're all arguing over juvenile court, and nobody can see what the hell happens there. One at a time.
Melissa, do you want to answer that?
So, Chris, I don't want to comment on the policy of it, but you may recall maybe 15 years ago, the legislature passed a statute that allowed reporters to cover juvenile cases, but it was on the delinquency side. Excuse me, it was on the child protection side. It wasn't on the delinquency side. It was very controversial. We surveyed the judges. 50% thought it was a good idea. 50% thought it was a bad idea. But at the end of the day, reporters really didn't cover the proceedings, and the legislature decided to repeal that. So I add that comment. And the other thing I will say is this past session, legislature passed legislation that requires the judicial branch to keep track of any time a law enforcement officer asks a judge to take a juvenile into custody and what the outcome is. So we don't have that information, but we are collecting it now prospectively because of that statute. So there will be some information that will be available, but clearly not all the information that you would get if these proceedings weren't open.
Yeah, I appreciate that. And of course, you know, we had the law that was passed, a couple of years ago to transfer juvenile cases, serious cases, to adult court and then keep them secret there. And fortunately, that was found unconstitutional, and the state has declined to appeal it anymore. You know, I don't expect a lot of support in the legislature to open juvenile court to the public, but if judges ever thought it was a good idea, I'd be delighted to hear about it.
I'm not sure that any of the judges are going to comment on that, just because if it ever becomes litigation, it could be in front of us. But we
You
hear
may
you
not be sure,
loud and
Judge
clear.
Alexander, but I'm positive that none of them are going to comment on that. So
Yeah.
I think that's
I'm being diplomatic. That's a rarity for me, okay?
Any other comments?
Eric, I just wanted to mention that I would be happy to bring John Shugart's suggestion to Ty Erickson, the Executive Director of Court Operations, and to Don Murph, who is in charge of the marshals. I know they have roll call, and we can just mention that this was a concern, and hopefully at roll call, they can just reiterate what the current rules are.
Yeah, that'd be great.
Is there any other discussion that our members would like to have before we adjourn?
Well, this is Powell again. I just feel obliged to thank the department for the heroic efforts to try to keep things open amid these awful circumstances we're going through. And I hope the epidemic ends soon and we can go back to the normal problems. But in the meantime, I think it's amazing what you've accomplished for keeping the system as transparent as it has been. So thank you.
Agreed.
Rhonda, you're on mute.
You're still on mute, Rhonda. We can't hear you.
Sorry about that. I thought I hit the right one. I've got a April 2022 calendar. If you wanted to tentatively set the next meeting date, TBD, whether it's remote or in person. But the Mondays are April 4th, April 11th, the 18th, and the 25th. Would you want to set one of those aside? With the understanding that we can change it if we need to.
I'm fine with whatever if someone has a preference.
You want to make it April 11th?
April 11th.
Yes.
You know what? Well, I'm gonna voice just April 11th is a school vacation week. I don't know if anyone else has
Oh, we
that.
don't want that then.
Probably
No,
so.
No.
Yeah,
I
we
don't know
don't
if it's,
want that.
it happens to be in West Hartford. I don't know if everyone has that, but
No, that's
Maybe-
not a good week.
Maybe April 4 then, because the 18th might be the other half of the state.
Yeah, you want to do April 4th? April 4th.
That keeps it away from sweeps for TV people.
Agreed.
Yeah, and the next weekend is our next Monday's right after Easter there too.
Okay.
So yeah, the 4th is pretty good.
Okay, April 4th, 3 p.m.
Cool.
Right.
All
I
right.
think we're complete. Thank you. Eric, you want to say anything else?
I was going to say the same thing.
Thank you very much for attending. We'll see you in April. Stay healthy and safe.
Okay, you too.
Yeah.
Thank
Aaron.
you,
Thank you.
everybody. Bye-bye.
Take care.
Bye-bye.
Bye.